We are live. Hey, good morning. It is April 23rd in Senate Judiciary. We're taking up page 772. There are some time constraints, so we're actually starting from the bottom with Chad Simmons. So, introduce yourself before it goes.
Great. Thank you, committee. For the record, my name is Chad Simmons. I'm an executive director in the Housing and Homelessness Alliance in Vermont. I really appreciate the committee flexibility and the schedule. I'm hoping that I'll be right next door in just a few minutes. So I submitted my testimony. It's a little bit longer than what I'll share verbally right now. Our organization is a membership organization. We represent organizations, individuals, so faith-based organizations, nonprofit, housing organizations, and shelter providers from across the state that focus on dual mission of ensuring that we prevent homelessness from happening and respond to it when it does happen, as well as creating a safe, affordable, and accessible housing in Montgomery. We really appreciate the opportunity to discuss 772 as it passed by the House. We have a number of concerns with the overall, a number of concerns with the bill, and feel like it sets us up for creating additional challenges to our homelessness and housing system. That being said, we do support a couple of very narrow provisions as passed, and would like to propose. I know the Senate Economic Development and Housing and Criminal Affairs is also working on some language around improvements to the court system, looking for efficiencies. So I'd like to just speak briefly to those couple of key areas that we do support in the bill. The first area is two kind of narrow provisions offered by our nonprofit housing network and our members to expedite the notice process and for rental agreements and terminating those in the event of threatening behavior or safety issues that pose safety issues to tenants. We feel that this is an adequate shift and expediting that process for very narrow parameters around safety related issues. We did in our memo include draft language that we also shared with Senate Economic Development. The second is,
are you able, sorry to interrupt.
Yeah,
are
sure.
you able to just briefly highlight or just tell us what the draft language is for that?
Sure.
One section.
So this this looks at section 1, pages 8, lines and page 9. So line on page 8, lines 16 through 20, and page 9, lines 1 through 2. And we are proposing that we keep in criminal activity, strike out illegal drug activity, and then put in the words, any of which is an ongoing and repeated threat to the safety of other residents.
And you're proposing striking out the rest where it says landlord or landlord agent and neighbors.
Yes, and I'm sorry, just neighbors, so that the landlord or landlord's agent would have any threatening behavior towards those individuals. And we struck out neighbors because some of our members, and I should have said this up front, our membership is broad, and our membership also has divergent perspectives on this bill. So we we've kind of landed and tried to land the plane as it were in a meeting ground.
I recognize that you're not our attorney, but that it's sort of posing a threat. How is that defined? I feel like that could be a fairly subjective.
Sure, the landlord would have to, so the property manager and the landlord would have to show evidence and provide proof that threatening behavior is both ongoing and is towards the tenants. So essentially, they would have to show evidence of.
Yeah, so I guess my question is, what is threatening behavior? Is that I yelled at your dog 3 times? Is that I sit in my house by myself and yell because I'm struggling with a experience, but it's not consensual. Like, what is threatening behavior? Is
Sure.
it actually physical threatening behavior? What does that mean?
So I think some of the testimony that's been given in other committees and our members have shared kind of ongoing pervasive violent behavior. And I think that those instances are the ones that are the reasons why we're bringing this proposal to the legislature for consideration. So I would say it could be a variety of things, but we are really focused on those acts of threatening and ongoing behavior.
So I wonder if you would be comfortable with violent behavior as a threatening behavior, given the sort of subjectiveness of what is threatening. I mean, I might feel threatened because someone is a tall black man. I don't, but there's a lot of area for subjectivity and bias and do you just sort of see what my concern is with that language?
Yeah, I understand that. I think there are ways in which, though, again, our members have shared with us that not all activity is, and not all instances are violent, but they pose risk and to the tenants. So we've been kind of looking at this from a tenant protection in the same way.
Okay.
So,
just to follow on Senator Olszewski's. We are in sub 2 on line 16 and following,
yes, correct.
because it does say acts of violence. And then it says threatens the health or safety of other any other activity. So it seems like your point, if I'm understanding the change you want to make, it seems like it's already there in acts of violence. My question, other than that, is, do you go along with the last line, moving from 14 to 5?
Yes.
You do. And just quickly, the reason for that from your collective perspective.
Sure. So as our members have shared with us, expediting the process a little bit would help them create a safe environment for tenants to live in. And so that little bit of time moving the process forward would be able to allow for folks to our nonprofit providers be able to move the process quicker to ensure the safety of the tenants. So we do.
Because I wouldn't necessarily characterize it as a small change, it's reducing it by almost 2/3.
Yeah.
So 5 days does seem quick to be fine.
And again, I think we would only agree with this change proposal in this very narrow focused instance. Because as I shared earlier, we do have concerns with broadly expediting the process for a variety of reasons, as you pointed out. I think it is a fair point.
Thank you.
So so where left off is the second piece that we are in support of is the ability to issue a trespass order for any tenants invitees. Again, this would be in the cases of threatening behavior as well, and an ongoing activity, and that would if the tenant consents to the no trespass and the invitee violates the terms of the rental agreement for state or federal law. So those are the two narrow provisions that we are in support of and making those changes. Again, I think our goal is that this bill be narrow and focused and make incremental changes to landlord tenant.
So you support the no trespass section as it's written?
Correct.
And generally everything else in the bill opposed, agnostic.
There are a couple of other sections that we do, and I know you'll be hearing from a couple of other advocates that we do support, but by and large, we feel like the bill is too broad and makes too many changes. I think a number of our members have shared that if this bill were to move forward with the effective date as is, it would make it almost impossible for us to be able to respond adequately to provide the updated education and information to and legal services to folks involved. So we feel like just having a narrow component of that The other thing I didn't mention explicitly, but that we go into a little bit more detail in the memo is looking at ways to improve the court process and expediting and looking at ways efficiencies can be made in the court, and that could include also looking at specifically a standalone housing court that would look at these specific cases that's outside of the court proceedings. So that could speed up the process as well.
So those.
I have a question about the no trespass, and it may be for you, it may be for legislative council. So if a tenant consents to a no trespass order, couldn't they just get the no trespass order themselves because it's their house? Is there some reason why it makes more sense for the landlord to do it as opposed to the tenant?
It's a good question. I'll let council answer, but I do have a response to that as well from our members.
The legal, Cameron Wood, Office of Legislative Counsel to the record, the legal answer is that there would be nothing that would prohibit the tenant who has, wall occupation premises from issuing a trespass.
Okay. Is it somehow legally more powerful if the landlord does it?
Not to my knowledge from a legal standpoint.
Okay.
I think if, my take on it is there could be domestic situations where the tenant may not want to be the one who issues it for fear of retaliation of their partner. And, coming from a landlord, then the tenant has more standing to say, I had nothing to do with that. It was the landlord. Whereas the landlord and the tenant could be actually agreeing with each other to issue that no trespass. There are also other situations where there are folks living in a space and it's not entirely consensual with the tenant that they're living there, but the tenant doesn't quite know how to reclaim their space out of fear. So it's something that I've seen a few times in Brattleboro, but
And that was one of the examples I was going to give in my previous work. I did support for communities dealing with and experiencing substance use disorder. And that we found that to be a case oftentimes seen where people were intimidated and folks were essentially had to took over their apartment. So we were also hearing from members too that those kind of intimidated acts of threatening behavior put enough fear in a tenant's case that they wouldn't feel comfortable doing that. I think the final thing I'll just mention is you'll hear from advocates shortly from the Vermont Network that they're proposing some language changes that would support make additional protections for folks experiencing domestic and sexual violence. And so we support the language that they'll be proposing to ensure tenants can report instances of violence without fear or risk of losing their housing. So I think this is just another clear example. And then there are overdose protections in the bill as it exists that we do agree with and support. And those essentially say that tenants would be protected if they call or ask for medical assistance in cases that oppose those.
thank you. Any other questions? Yeah. Good, thank you.
Thank you, Smithy.
We'll go back to the top of the list, Jessica Hyman. She was last there. Morning.
Good morning. Thank you, Chair Hashim and Senators. For the record, my name is Jess Hyman, and I'm the Associate Director of CVOEO's statewide housing advocacy programs, including our Fair Housing Education Program. As you probably already know, CVOEO is one of the state's 5 regional community action agencies, and we work to advance economic, social, environmental, and racial justice, and we support people in achieving economic independence. Most of our programs serve the Champlain Valley area, Franklin, Grand Isle, Chittenden and Addison counties, and our housing advocacy programs are statewide. So we work with renters, people living in manufactured home communities, and individuals experiencing discrimination all over the state. As part of that work, we respond to more than 3,000 calls and emails each year through our helplines for renters and manufactured home residents. We provide rights and responsibilities trainings for renters, landlords, municipal officials, and service providers. We offer housing stability and eviction prevention support. We work with SILEs, and we have a temporary housing voucher program. So to allow time for questions today, I'm just going to cover the first little bits of my written testimony. I invite you to review it in full at your convenience. So I'm here today to share some deep concerns about 772, make a few policy suggestions. If there's time, talk a little bit about the connection between education and early intervention and policy, and reinforce some funding requests. So please note, I'm not an attorney, and I'll happily leave the legal analysis to experts like Legislative Counsel Cameron Wood and Jean Murray of Legal Aid and others. However, I do have many years of experience working with tenants and landlords and people experiencing illegal housing discrimination. And I can speak to the impacts of the significant changes to landlord-tenant statute that are proposed in 772. For context, every day here at CVOEO, we hear from renters who are facing threats to their housing stability, and they often get to us only in the last days of their notice periods or after they've opted to needlessly leave their homes after a termination notice or an illegal eviction. And renters are often really scared to speak up and also to enforce their rights. Often because they fear retaliation. And this is especially in areas where a few landlords control the majority of the rental market. Granted, when we hear from renters when things aren't working or aren't going well, and we know that a large amount of the landlord-tenant relationships around the state are positive and fair. And that's another one of the reasons we have big concerns about 772. So our biggest concern is how it will disproportionately impact vulnerable communities. We recognize there are very real safety challenges and caused by a small number of egregious situations. And however, this bill significantly reduces due process for Vermont's approximately 76,000 renters. And these changes will harm people with disabilities, people with limited English proficiency, and those already subject to discrimination and harassment. So shortening the eviction notice and response timelines overall makes it harder for tenants to access legal representation, eviction defense, or emergency rental assistance. And the bill also makes multiple changes to landlord-tenant law that weaken existing renter protections. And some provisions of this bill were intended to strike a balance. We understand that, but the cumulative impact creates unnecessary harm. We also have concerns about parts of the bill that would codify landlord fees, such as background check or credit check charges, despite the existing statutory limits on application fees. Other provisions, such as shortening the timelines for non-payment and breach of contract from existing statute, including posting notices on the doors, actual notice, and including provisions such as repeated late payment, refusal to allow landlord access, termination for no cause, and the undefined other reason for expedited eviction are also problematic for us. We feel that current statute has maintained a good balance between landlord-tenant rights and responsibilities, and 772 disrupts that balance. So few alternatives to consider. If the core issue is the length of time eviction takes to move through the courts, we believe that problem should be addressed by increasing court capacity or establishing a housing court rather than eroding due process for all renters. Similar to what Chad mentioned earlier, CVOEO would support a separate approach that allows for expedited resolution in truly dangerous situations, but only if that's paired with tenant protection, such as limited rent increases, good cause eviction policies, and stability retention services. This type of carve out for housing providers, which would be mostly the nonprofit housing providers that have these practices, could be made separate from the existing bill as a way to address these landlord and community safety needs without the cascading impacts of other changes proposed in this bill. Additionally, we think that any expedited process for landlords should be matched by expedited hearings for tenants, especially in cases involving habitability or landlord noncompliance. And we highly support right to legal representation for tenants in eviction cases, as well as funding for rental arrears. So we're not supportive of the bill as written. However, if it is to move forward, there are a few fundamental changes related to termination notices and eviction timelines that would preserve tenants' rights and due process while addressing the stated landlord desires to expedite the eviction process in certain extreme situations. So we would, I've got a couple specific lines that I wanted to comment on. So on page 1, removing all the new language added to the bill. I think existing statute does a good job of defining actual notice, including the delivered by sheriff's service isn't necessary. That's already included under hand delivered. That would be included. So, and then moving on to online page. I'm sorry, I'm losing track of my notes here. It's a long bell. So we also would highly recommend keeping the existing notice timelines for non-payment of rent, which is currently 14 days in statute, and for breach of rental agreement, which is 30 days in statute. Those work. I think they work for tenants. Generally, they work for landlords as well. We would like to see on page 7, removing repeated late payment as a cause for termination. It's a cost of doing business. We would also like to see on page 8, line 10, removing the tenant refusal to grant access as a cause for termination. On page 8, looking at restoring the words criminal activity and adding actual or imminent threat to refer to the definition section. I also want to note, just to uplift Senator Wachowski's point about how you define threat, and threat, using the word threat could be an opportunity for bias or discrimination. We just wanted to flag that. So it's important to have that defined well. Also on page 8, line 17, we would like to see the overly broad wording or other activities removed. This could make it easier to discriminate against people with disabilities, BIPOC, LGBTQ plus folks, and others in protected classes. That other activities is too vague and not a rationale for eviction. As I mentioned earlier, we would support a carve out for certain housing providers who have good tenant protection policies to have an expedited eviction process. However, we still believe that 5 days is far too short. So I'm on page 9, line 1. 14 days 14 days is what's written in the existing statute. 5 days is far too short. That's not enough time to ensure due process and access to support, especially for people with disabilities, folks whose first language isn't English, and other vulnerable populations. So for example, if the actual notice was given on a Thursday, 5 days would take it to Tuesday. That gives a maximum of 3 business days to seek support, legal assistance, etc. It's just not enough. We would support something shorter than 14 days, but definitely not as short as 5. On page 9, line 4, we'd suggest adding under the threat of perjury to that paragraph to make it clear that a landlord can't just make up a reason for that.
Sorry, which page and line number was that?
I'm sorry, page 9, line 4. So that's the section that talks about the attestation. And let's see, on page 10, lines 7 to 8 and also 21, we would remove government notice to vacate from that list. That's unnecessary since state and local inspectors already have the power to order a tenant to vacate if there are habitability issues. And let's see, page 11, line 4. We would remove or repurposed. That's as a vague term. And there are a number of other line edits that we would make in this bill, but I thought that those were most relevant to your discussion today. Any questions on those?
I think just regarding page 9, line 4, you're referring to the actual notice required under the subsection shall be accompanied by an affidavit. And I don't know that it's necessary to create the risk of perjury there, because if you're, that's inherent in filing it's a sworn affidavit. If you're filing that with the court, I believe there's already an inherent risk of perjury if you're lying on an affidavit.
Good point.
But just one small point I want. That was it. Committee.
Thank you.
Oh, yeah. Sorry, did you have anything else, or did you want to?
On the other, I just wanted to conclude by just noting the importance of education and early intervention in any policy change. So the education that we do for renters, for landlords, for municipal officials and others is really critical to helping everyone understand their rights and responsibilities under the law. There's this link between policy, law, and education. And the more everyone understands what their rights and responsibilities are, the better the system works. That's why we've asked for the reintroduction of some of the funding that was in the original bill, which is housing education and landlord liaison positions, to help build that educational foundation and also the relationships as well. In closing, I respectfully urge the committee to protect due process and vulnerable Vermonters while addressing serious safety concerns. As I said before, we do not support the bill as written. We would support a separate carve-out that could allow for some expedited evictions in very specific circumstances when there are other renter protections in place, but not in the context of this bigger bill that has far too many changes to existing renter statute. So I really appreciate the opportunity to testify today. I appreciate the work that the committee is doing, and I'm happy to answer any other questions or turn it over to the next witness. Thank you.
Thank you. Just a quick comment, or maybe this is a question, but made me think of it regarding the education piece that you had described. And I'm wondering if pushing out the effective date by, I don't know how long, but pushing it out by a little bit in order to allow all these different organizations to update their materials and get information to their tenants, but also to allow landlords and other housing providers the opportunity to, meet with their counsel and, figure out, what rules or how the rules are affecting them as well. And the effective date is July 1, which is pretty soon. So generally, would you be supportive of pushing out the effective date a little bit?
If this bill passes, yes, we would absolutely want to see the effective date pushed out. That's not enough time to get even the most basic of information out to landlords and tenants. And there are all the printed materials, information on websites, outreach that would need to happen from both the tenants advocates, landlord advocates, and other community groups that would take a significant amount of time to make sure that everyone understands these significant changes to existing statute.
Thank you. Committee, any other questions?
One of the things you pointed to with the 5-day window being too short, given that in some instances there may be only 3 business days to find legal counsel. Is there currently adequate legal counsel for tenants seeking support in these areas?
Absolutely not. There's a huge need for more representation for tenants. If you look at the percentage of landlords who have legal counsel in eviction cases versus the percentage of tenants, there's no comparison. I think Jane could give you the exact percentages on those, but we're already seeing a lack of support, a lack of access to resources, and a lack of access to the legal system from the tenant population. And so shortening the process exacerbates the existing issues that are resulting in a really unfair and unbalanced situation for renters in the courts.
Thank you.
Any other questions, Senator Norris?
Yeah, Jess, in looking at page 9 of the 14 days, you found to be not acceptable, or the 5 days, moving from the 14 days. Of course, you realize this particular notice falls under page 8, line 16. And the termination is based on the health and welfare of individuals, illegal activities, so on and so forth. And it simply speeds up, it's my understanding, it simply speeds up the process because the eviction notice is part of the process. It's nothing more than an invitation to please leave by this date. It still doesn't jump over the judicial review as far as obtaining a summons, a complaint, getting your time in court, and so on and so forth. So I can understand the 5 days notice on this just due to the circumstances here. This is not late payment of rent or anything. These are extraordinary circumstances where they may be. So I guess I'm a little concerned as to why the 5 days may upset you.
Yeah, that's an excellent point. And in these extreme situations, there should be an expedited process. However, on principle, we want to make sure that everyone has access to due process, and everyone is innocent until proven guilty in general. And so we wouldn't want to change. That's why 5 days just seems far too short. But less than 14 makes total sense. So if it were, for example, 7 days, that could give folks access to basic legal supports, and still shorten the process considerably.
Thank you.
You're welcome.
Any other questions? Great, thank you very much.
Okay, thank you.
Charlotte?
Good morning. Carly Glisserman, I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I'm joined by my colleague Katarina.
I'm Katarina Lesias, the advocacy and organizing manager at the Vermont Network Against Domestic and Sexual Violence.
And we appreciate the opportunity to share a proposed amendment to H772 with the committee. I will provide some background on the language that's specific to survivors of domestic and sexual violence that's currently in the bill. And then our proposed amendment, and Katarina will walk through the language in a bit more detail. And that language is posted on the committee's website.
Do you happen to have hard copies of that?
I do not, but I'm happy to print some off after we have provided.
No problem. We get hard copies, but shortly. That's all right. Thanks.
Thank you. So the intention of this proposed amendment is to clarify the protections for survivors of domestic abuse, sexual assault, and stalking within the bill and support their continued access to housing. In 2025, the 14 member programs of the Vermont Network provided emergency housing to over 1,000 individuals who were fleeing violence. Collectively, these programs serve every town in Vermont, supporting survivors through emergency shelter, motel overflow, transitional housing, rapid rehousing, and assistance accessing the GA emergency housing program. The linkage in 772, specifically language on survivors in retaliatory conduct prohibited, termination of tenancy, and a right to bifurcate a rental agreement, seeks to ensure that tenants can report incidents of violence and request assistance without risking losing their housing. It also affirms that a tenant's housing status should not be adversely affected solely because they are a target of violence. To ensure these protections are implemented as intended, we have a proposed amendment to clarify and improve them as operationalized. The proposed amendment would do a couple things. It would establish a notice of tenants' rights that is provided by the landlord a couple key points in the process, including at the time of an eviction notice. It would clarify the process for lease bifurcation for survivors, and it would also adjust language, including removing one piece that was in the House Pass bill to better align with our existing state and federal housing protections for survivors, and also minimize any unintended consequences for survivors. These updates draw from a few different places, from stakeholder feedback, some of the testimony that you all heard in this committee, as well as a bit more research and review of some existing standards in the Federal Violence Against Women Act, VAWA, and current state law protections for survivors in their housing currently. We appreciate the time, and I now feel like I have to waste time until Emery comes back with your printouts. Or would you like us to hop into the language review?
We can, I'm sure he'll be back momentarily, so we can hop into the language.
Okay, perfect. Well, thank you. Katerina, go ahead.
So our first suggested change, as Charlie mentioned, is a notification of the occupancy rights. We suggest the Housing Division of the Agency of Commerce and Community Development that they shall develop a notice of occupancy rights under Vermont and federal law, including information related to the right of confidentiality pursuant to 94474. I'm sorry, I'm not the lawyer, but so in order for tenants, to explain why we want this, in order for tenants to be aware of various protections, we believe it's important that there be notice at key points in the process, from the beginning of the rental agreement to the denial of a housing application or eviction. This language is modeled on the Federal Violence Against Women's Act provision, which currently applies to tenants in public housing or who receive federal housing assistance. I'll keep moving on, but please feel free to ask questions at any time. The second language, or the next part that we'd like to add, is the notice shall comply with the Office of Racial Equity's most recent language access report. So again, the notice should be accessible to all renters, and language should not be a limitation. The language accessibility text, this language accessibility text is used in other areas of Vermont law, so that's where we pulled it from. And then the final part of that section of the amendment is that the landlord shall provide the notice developed under this section to an applicant or tenant at the beginning, at the time the individual is admitted to the dwelling unit, at the time the applicant is denied residency in the dwelling unit, or with any notification of eviction or notification of termination. So as
Sorry,
shared.
one second.
Yeah.
Senator Ruth?
Just a clarifying question. So
Please.
when you say admitted to, does that mean they've been cleared to live in the space, agreement signed?
Yes, that is what that
Okay.
is.
And then denied residency, how is that different from being evicted?
That would be if there's an application process and
They
you've
just
been
didn't
denied.
get the
Yeah.
apartment.
Yep.
So does everybody get the notice or just people in the protected class?
We think everyone should get the notice.
Okay, so in other words, if a landlord has many people apply,
Right.
they're required to notice everybody who doesn't get the apartment.
Yes.
Okay, thank you.
And there is a summary at the end of our testimony of some current state and federal housing protections that, are already in practice here. This notice of occupancy rights is included in federal VAWA protections, which applies to a variety of housing providers that are currently in Vermont. Here, I'm just getting the list. Anyone who lives in public housing, anyone who has a Section 8 voucher, or lives in a rental unit that receives federal housing assistance. And so when we were thinking about, what might be feasible in protecting the rights of survivors in housing, we tried to look at what is already in practice, what landlords are already able to do. And this occupancy rights was one of those pieces.
Senator Bowers?
I'm curious on B there, it's denied residency. You have to provide notice. What type of notice? Can I send a text? Can I make a call? Do I have to send a letter? What can I do?
So I think it would depend on the exact format that ACCD would establish the notice, and I would, perhaps defer to other folks, legal aid, maybe Jessica at CVOEO, who have a real clear idea of this process. But I could imagine it could be a link to the notice that is posted on the ACCD website, or a PDF that's attached to an email, if we're getting into the nitty gritty.
In the interest of staying in our lane as Senate Judiciary, I do think this specific notification falls more so into economic development's jurisdiction. Not that I'm opposed to it necessarily, but I think this is something that would come more so on their committee. But happy to shift gears and look at the other pieces, which I do think fall more so into our committee.
Perfect.
All right. So the next part is about bifurcation of the lease, which is in a few different parts of the bill. So in termination of tenancy notice, there's language that says, currently says a landlord shall allow a protected tenant, should allow a tenant. And we would like to just update that to be a protected tenant who is a victim of domestic abuse, sexual assault, or stalking committed by another tenant or lawful occupant, and add may request to bifurcate the rental agreement. So changing a shall to a may. We are suggesting this update to the bifurcation language so that it's better aligned with VAWA and existing state housing protections for survivors. And then as we get to the next parts I'll talk about, you'll see that slight change. But we would like to strike the next part of the termination of tenancy, and that is we added this language. This language was added in the House with the intention of aligning with VAWA protections. But with further research and stakeholder feedback, it doesn't accomplish what was intended. So we just asked that it be removed so it reduces any unintended consequences for survivors. So for the next part regarding bifurcation of the rental agreement, this is the bifurcation part of the bill, that we would again change a shall to a may, and then authorize a protected tenant's written request to bifurcate a rental agreement language in that. So like our comments just before, we're updating the section to reflect that a landlord may authorize bifurcation of the lease to align with the VAWA and existing state housing protections for survivors. The next part would be a slight change. That would be allowing a protected tenant who includes with a written request a copy of a court order that requires the perpetrator to leave the premises. So a landlord shall bifurcate a rental agreement in order to eject, remove, or terminate a rental agreement to any individual who is a tenant or lawful occupant of the dwelling unit that engages in abuse, sexual assault, or stalking against the protected tenant without ejecting, removing, or terminating the rental agreement with the protected tenant. So this language is also drawn from existing housing protection provision in instances when a tenant has a court order requiring the perpetrator to leave the premises. So the landlord must require that bifurcation of the lease. A court order, like a relief from abuse order, already outlines a fear of future abuse and conditions to protect the plaintiff survivor's safety. So it is critical for the safety of the survivor and their family to be able to remain housed and have conditions of relief in their order to be effectuated through their interactions with the landlord. Any questions about that?
I have a question about the next.
Right.
It says nothing in the subsection shall be construed to require a landlord to request that the protected tenant submit documentation. I'm just wondering then, can the landlord deny? So it doesn't require them to request documentation. Could they, in the absence of documentation, refuse to bifurcate?
Yes, well, so if let's go about it the other direction so that I understand what you're saying.
Yeah.
So if a tenant includes a written request for bifurcation and has a court order, the landlord must bifurcate. If the landlord submits a written request to bifurcate and does not have a court order, the landlord does not have to bifurcate. Or, and, I guess is the,
So basically, we're just saying the landlord is not compelled unless there's.
Correct. And, I think this provides the landlord with discretion and an option in the absence of a court order. And we just want to, be very clear that a landlord is not obligated to collect further documentation in order to grant that request.
Okay. Because it seems like it cuts the other way, like it's allowing the landlord. But it's in the section talking about a court order. So,
right, I wonder if we make that A2 and this last part, and the one that's A2, A3, so that it's associated with the may rather than the shall. I think that might be where the confusion is.
yeah, I don't know. I think I'm clear though. So landlord is compelled if there's an order and a request. Absent court order, the landlord is not compelled. I guess it's the submitting documentation. So there is no circumstance under which the landlord has to respond to documentation. It's just a court order that they.
Right.
So I'm confused about what documentation's role is. In other words, if there's court order, there's no need for documentation. If there's not a court order, documentation won't necessarily happen.
Right, it would prevent a landlord from saying you need to prove that you're a survivor to us if you don't have a court order.
the event that there's a court order.
In the event there's not a court order.
Right.
We're happy to work with Cameron on making sure that this language is very clear. We just want to ensure that the landlord does have discretion in those cases where it is a may, and that they don't feel like they have to do anything beyond that.
Well, and I guess that's what I'm asking is, in terms of protections for the threatened person,
Mhm.
in the absence of a court order, the landlord doesn't have to do anything.
That's a policy decision for you all.
Okay.
Senator Madison.
I'm curious about costs involved here. If it's a court order to eject that person, I'd imagine there's nothing that needs to be done landlord wise, having to go through the court system or anything like that. If it gets to the point where this person doesn't leave, is the landlord on the hook for then ejecting that person? If the landlord may, is it on the landlord to go through the process to eject that person? It's just, where do those costs fall in the process?
It's a great question. So this language is modeled off of a current process that we have in Vermont law for when a survivor needs to change a lock on their rental unit for their safety. And so it would work pretty similarly to how that process is. Exactly how that works in court procedure, I might defer to others who are more familiar.
I mean, I was wondering that somebody in this type of situation, but just where those costs kind of fall.
Of course. And, I would also note that, there are so many individual situations that would implicate some of these tenant protections. But I'm sure in many cases, the landlord is also interested in ensuring that their housing units they're providing to tenants are safe. And so this is, certainly a benefit to survivor, but also giving a landlord discretion to ensure that that their units are kept safe without feeling like they have to evict a survivor, because that's the worst case scenario that we can think of.
I do have one question that I think is somewhat in line with Senator Mattis's question. The acquiring this court order, the victim acquiring the court order, what does that process look like? Is there something that exists in current law for that procedure, or How does that, what does that look like?
Exactly. So that court order, I think, could look like a number of things. It could be a relief from abuse order that has as a condition, a stay away or housing conditions within it. It could be conditions of release, that also have, a requirement for the perpetrator of harm to stay away from the premises. Maybe it could be a trespass order, depending on the individualized situation. So those are the things that we thought of when looking at this language.
Okay, and that's helpful because I wasn't sure if there was going to be the creation of some sort of other court order telling, okay, all right, that's very helpful. Sarah Morris.
Yeah, I would need a little help with this. So are you trying to, on page 9, starting on lines 14 through 20? This doesn't cover a portion or some of what you're attempting to do here, or what does that mean exactly?
So looking at page 9, line 14, a landlord shall not terminate a rental agreement of a tenant under this subsection B because the tenant is a victim of an incident or pattern of sexual assault, domestic abuse, stalking. So, that is intended to protect survivors, saying because of your victimization, solely because of your victimization, you can't be evicted. And then in the next section, a landlord shall allow a tenant who is the victim of abuse, sexual assault, stalking committed by another tenant or occupant to bifurcate the rental agreement. So that is noting a process that is then further described in the right of bifurcation. So
Just going further than what we're seeing in the bill here, what you're trying to do.
So this right to bifurcation rental agreement is already in the bill. We are proposing some changes to clarify. So I would say the language right now gives landlords a lot less discretion, in fact. We are saying for the benefit of survivors, for the benefit of landlords, and also to align with current federal law and state law, this is probably the best way operational.
May I have your attention, please? May I have your attention, please? This is a building evacuation. Gather your belongings